Welcome to this Ultimate Explainer on South African contract law. If you are staring down a massive chapter on Unit 15 right now and wondering how you're going to possibly remember all the nitty-gritty details, well, you are in the exact right place. Today, we are going to unpack every single tricky legal concept, every Latin phrase, and all those super strict rules from the source material. We're going to break it down so you can completely memorize it and crush your exam. Let's get into it.
Okay, here is our roadmap for today. We've got 6 big buckets. Number 1, roots of legal obligations. 2, anatomy of a contract. 3, the mechanics of consensus. 4, time, place, and communication. 5, terms and future contracts. And finally, number 6, factors destroying true consensus.
All right, Section 1, Roots of Legal Obligations, the DNA of law. To really understand South African contract law, we have to look at its Roman-Dutch DNA. You see, an obligation creates a literal legal tie between people, and these ties they split down 2 totally different paths. On one side, we have non-juristic acts. This is where the law imposes an effect entirely regardless of your intent. Think of a delect, like if you accidentally cause a car crash and harm someone. You didn't intend to be legally bound to pay them, but the law says you are. On the other side, we have juristic acts. Here, the law gives effect specifically because of your intent, and this is exactly where a contract sits. It's a multilateral juristic act, meaning it absolutely requires the intentional cooperation of more than one person to create that legal tie.
Now, you've got to remember that not all obligations are created equal. With a civil obligation, the law fully has your back. Your rights can be strictly enforced by a court order. But a natural obligation? Well, the law recognizes that it exists, sure, but it absolutely cannot be enforced by a court. A classic memory trick for your exam, just think of a friendly wager. If you lose a bet to a friend, they can't drag you in front of a judge to force you to pay up. That is a natural obligation.
Let's talk about transferring these rights and duties, because this is a massive concept that examiners love to test. Cession is when you transfer your rights. Let's say someone owes you money down in Cape Town. You can cede your right to collect that debt to a friend. The cedant, which is you, and the new cessionary, your friend, agree. And here is the absolute key point. The debtor's consent is not required at all. Delegation, on the other hand, is transferring your duties. This is when you are passing off your own debt to someone else. Now, because the creditor needs to know exactly who owes their money, this requires a tripartite agreement. That means the original debtor, the new debtor, and the creditor must all consent. You need all 3.
Section 2, Anatomy of a Contract, Building the Beast.
So, how do we actually build a valid contract? The source material gives us a super strict 5-part checklist. You need to mentally file these away right now. Number 1, consensus. The minds of the parties must meet. Number 2, contractual capacity. You have to have the actual legal capability to form intent. Number 3, legality. The contract cannot go against public policy. Number 4, physical possibility and certainty. The performance has to be physically possible and clearly determinable. And finally, number 5, formalities. If there are any legally prescribed written requirements, they absolutely must be met.
But what happens when things go wrong? Guys, this is a classic exam trap, so pay close attention. If even one of those 5 requirements we just talked about is missing, the contract is null and void. It literally never existed in the eyes of the law, and no obligations are created. Full stop. But what if a contract does come into being, but it involves some sort of improper conduct, like someone lying to you? Then it is voidable. The obligation exists, but the wronged party gets to make a vital choice. They can choose to set it aside, or they can choose to keep it. And then we have unenforceable contracts. Like those natural obligations we discussed earlier, they create the legal tie, but the courts simply won't enforce them.
Section 3, The Mechanics of Consensus, Meeting of the Minds.
Let's dive deep into consensus. Think of this next part as the rule and the exception. In South African law, our general everyday rule is the will theory. That means there must be an actual real agreement with corresponding intentions. But what happens if there's a material mistake and the actual inner intentions of the parties just don't match up? That is exactly where the reliance theory swoops in as our safety net. If one party created a reasonable reliance in the other person's mind that consensus was reached, they can still be bound to the contract. And then there's the declaration theory. That one says you are bound only by what you expressed out loud, ignoring your true inner intent entirely. But listen closely, that is not applied in South African law.
You build consensus to a firm, complete offer and an unqualified acceptance. Remember, any qualification you add turns it into a counteroffer. But an offer can instantly terminate before it's even accepted through 5 deadly events. I want you to remember this acronym for the exam, RRLDC. That stands for rejection by the offeree, revocation by the offeror, lapse of time, death of a party, or loss of contractual incapacity. If any single one of those events strikes, the offer is completely dead.
Section 4. Time, place, and communication. Pinpointing the spark.
The law actually maps out human communication in 4 very distinct phases. First is declaration, which is when the acceptance is made. Then comes expedition, when that acceptance is physically dispatched. Next is reception, when it reaches the offerer's inbox. And finally, information, which is when the offerer actually reads it and takes note. Now, what's really interesting here is that South Africa defaults to the information theory. The contract officially sparks into existence the moment the offerer takes note of the acceptance. But you absolutely have to know the exceptions. We use the expedition theory for postal contracts, and we use the reception theory for data messages, like emails and WhatsApps.
Section 5. Terms and future contracts. The fine print.
In law, we have a special term for agreements that are aimed at making future contracts. They're called pacta de contrahendo. You're going to see 2 main types of these. First, an option. This is when an option grantor promises to keep a very specific firm offer open for a certain amount of time for the option holder. A preferential right, on the other hand, is basically just a right of first refusal. The grantor isn't actually making a firm offer yet. They're just promising that if, down the line, they ever decide to sell, the holder gets the very first opportunity to make or receive an offer.
Okay, once a contract is actually formed through real consensus, all of its terms are going to fall into one of 3 Latin categories. Listen closely to the English root words here to help you remember. Essentialia are the essential minimum characteristics that identify exactly what type of contract it is. For example, if you're selling a bucky in Pretoria, the essentialia are the bucky itself and the price. Naturalia are the natural terms the law automatically injects into the deal, like an implied warranty against hidden defects. And finally, incidentialia are the incidental or extra terms you specifically write in to alter those naturalia, like if you say you are selling that bucky voetstoots or as is.
But what if you don't specifically sit down and negotiate the terms? Think about buying a GO train ticket. You don't sign a formal contract, but you are absolutely still bound by what we call presumed consensus. The courts use a really strict 3-step test for this. Step 1. Did the ticket holder know there was writing on the ticket? Step 2. Did they know that writing referred to contractual terms? If the answer is yes to both, you're bound. If the answer is no, the court moves to Step 3. Did the Gautrain issuer do enough to reasonably draw your attention to those terms? If yes, you are bound regardless of whether you actually bothered to read them.
Section 6. Factors destroying true consensus. The contract killers. Now we look at the sneaky diseases that can attack our perfectly valid contract.
First up is error, which is just the legal word for a mistake. The legal rules here are super strict. If you make an error in your motive, which is your personal underlying reason for contracting, or you make an error in the other party's name, the law just doesn't care. The contract is completely valid. But if there is a mistake regarding the actual person you are contracting with, the nature of the contract, or the specific performance, well, that kind of error destroys consensus entirely. The contract is immediately null and void.
However, the law isn't just going to let you wiggle out of a deal over some silly little mistake. It has to be an istis error. That translates to a mistake that is both reasonable and material. It literally has to go to the fundamental root of the contract's contents or its very existence to actually nullify consensus. If your mistake isn't reasonable and material, too bad, you are still bound.
Next up is improperly obtained consensus, starting with misrepresentation. This is a false statement made expressly or tacitly, either on purpose to defraud you or even completely innocently. If that lie influenced you to conclude the contract, here is the absolutely vital takeaway for your exam. Unlike a material error, which makes a contract void, misrepresentation means consensus was actually reached, but it was reached improperly. Therefore, the contract is perfectly valid, but it is voidable at your discretion. Then we have duress. Again, let's rely on the English translations here. This absoluta means absolute force. Imagine someone physically forcing your hand to sign a document. They are stripping you of all capacity, and as we know, no capacity means the contract is totally void. Now, compare that to vis compulsiva, which means compulsive force. This is when someone threatens you with harm. In this scenario, you actually still have capacity, and you make the choice to sign the contract to avoid the threat. Consensus was obtained, sure, but it was obtained improperly.
So the contract is valid, but it is voidable by the person who was threatened.
Our last contract killer is undue influence. This is when someone uses a relationship of trust to manipulate you. There are 5 very specific requirements you need to prove this. 1. They obtained an influence over you. 2. That influence weakened your resistance. 3. They used it for unscrupulous manipulation. 4. It directly caused you to enter the contract. And 5. It robbed you of your normal freedom of will. Just like misrepresentation and vis compulsiva, undue influence results in a voidable contract.
Let's wrap this explainer with a provocative, exam-style scenario just to tie everything together. Imagine this. If you buy a GOT train ticket under vis compulsiva because someone threatened you with imminent harm, is that presumed consensus contract null and void, or is it merely voidable? Think back to how we just separated absolute physical force from compulsive threats. If you know the answer to that, you are in a great spot. We have covered a massive amount of ground today, completely unpacking every nitty-gritty detail. I really hope this deep dive leaves you feeling totally empowered, highly prepared, and ready to absolutely ace your South African contract law exam.